I'm going to be talking briefly about aspects of asset protection, including when you would form a legal entity, and then I'll talk about power of attorney. Tobias will talk about revocable trusts, and then we'll give it back to Antu to talk about dissolution. Before I talk about power of attorney, I want to talk specifically about why do people form legal entities in general. People form legal entities in order to protect themselves from personal liability and to separate liability of operation of a business from personal liability. Another reason why people do this is to formalize ownership of a business, particularly when there's more than one owner. So if you have business partners and you want to allocate how much each partner's percentage of ownership of the business is, forming a legal entity gives you a way to do that, whether it's through a limited liability company or through a corporation. And that is connected with formalizing your ownership of the business, is also connected with the income that you're getting from the business and how much of it is taxable to you versus to your partners. Some legal entities include corporations, limited liability companies, and cooperatives. I put all three of these on the slide mainly to highlight that they're all forms of limited liability entities. And a limited liability entity is one in which the owners are liable insofar and up to the amount that they've invested into the business. So if I put $1,000 into my LLC and the LLC goes bankrupt because it has a lot of claims, it runs into debt, or there's claims brought by creditors, or various things happen, my risk is the $1,000 I put into the company. My risk is not my personal bank account and my car and my house. So that separation of personal assets from business assets is a core reason why people choose limited liability entities. And it's an important part of asset protection. When we're talking about asset protection in this webinar, generally we're talking about protection of all of the assets and wealth that an immigrant entrepreneur will be building up throughout the course of their lifetime. But we're also talking about properly apportioning and separating those assets between your personal and your business assets. But now I'd like to talk about another way to protect your assets and plan for the future. So some important resources I'll be referring to throughout my presentation are the Appleseed Guide, which is officially called Protecting Assets and Child Custody in the Face of Deportation. That's available at the link on the screen. The LCCR Guide, which is a guide for non-citizen business owners that we are going to be releasing next week. Everybody who's on our email list or who signed up for this webinar will get that. And then the California Uniform Statutory Power of Attorney form, which there's a link available in the PowerPoint, and we will be modifying that form and including it in the guide to be sent out. So the first thing I want to talk about is what is a power of attorney and why do people use it? So if you recall, when I talked about separating your personal assets from your business assets when you run a business, a power of attorney is another way to have control over your assets, whether it's your personal assets or your business assets. It's a document that allows a principal, which is the person here when we talk about the principal here, we're talking about the undocumented business owners, to choose another person who we're going to call the agent to act on their behalf with respect to finances, business, or child's care. A power of attorney allows a trusted friend or family member to act on a person's behalf in these matters with full legal authority. Neither person in the relationship, neither the principal nor the agent, need to be a licensed attorney to give or receive the power of attorney. The power of attorney can be very confusing because the term contains the word attorney, and the first thing I want people to understand is it is not required to be an attorney to use a power of attorney. Rather, the power of attorney grants another person the ability to act on your behalf. Why this matters in the case of detention or deportation is that it allows a business owner to efficiently settle their affairs in a worst case scenario. It allows a business owner to deal with all sorts of their life, whether it's their bank account, their safety deposit box, their house, if they need to sell their house, if they need to file a tax return, settle legal claims, appoint someone to be custodian of their children. And the Appleseed Guide goes into great depth about all of those topics. For today's webinar, we're specifically focused on businesses and business assets and how a business owner can use a power of attorney. So let's talk about specifically what does a power of attorney look like in California. California has what's called a uniform statutory form power of attorney. As I said, it's going to be provided in our guide as a modified version. This isn't the only type of power of attorney form available in California. Often third parties such as banks will have their own forms for you to use. This isn't the only type of power of attorney you can create. California provides this uniform form as a simpler way to create a power of attorney. You can draft a power of attorney from scratch, and you can approach an attorney, a licensed attorney, to help you with that. But what I want to reiterate here is that you don't have to have an attorney involved, and the guide has provided you a form to use. This is the form. The form it's called the Uniform Statutory Form Power of Attorney. It cites California Probate Code sections 4401. It provides a notice saying that the powers granted by this document are broad and sweeping. They are explained in the Uniform Statutory Form Power of Attorney Act, which is Probate Code sections 4400 to 4465. The powers listed in this document do not include all powers that are available under the Probate Code. Additional powers available under the Probate Code may be added by specifically listing them under the Special Instructions section of this document. If you have any questions about these powers, obtain competent legal advice. This document does not authorize anyone to make medical and other healthcare decisions for you. You may revoke this power of attorney if you later wish to do so. This notice is very important because it contains a lot of what I'm about to present to you about. And one thing I want to make sure you got from that notice is that this is not an authorization to make medical and healthcare decisions. For that, you need a separate healthcare directive. And for purpose of today's presentation, I'm going to talk specifically about your business assets and how to maintain or maintain control of those. So the first part of the form basically states who the players are. You have the principal. Here you put I, and then you fill in the blank there. It says name of business owner. Here we put in Betty business owner. That's the principal. Appoint, name of agent, i.e. Frank friend. That's the name of Betty's agent. And then you put in Frank's address. As you can see, it's not super complicated. This form allows you to fill in the blanks, and that's why we're recommending it as a form to be used by the public. So the next part is California allows for a general versus a limited power of attorney. First, what is a general power of attorney? A general power of attorney is one that gives an agent a wide range of powers, essentially enabling the agent to do almost anything on behalf of the principal. In California, a general power of attorney can be effectuated by a principal who puts their initials on the line next to option N. So on the screen right now, there's a list of powers, A through M. The principal can initial any of those powers to state which ones are granted to the agent. If the principal wants to grant all of the powers to the agent, they should initial option N. by initialing option N, they've created a general power of attorney. We don't recommend creating a general power of attorney. It's not necessary for most business owners. Further, it may be better to separate and create separate powers of attorneys for separate issues. For example, you can create one for business issues and have a trusted business partner, and then another one you could create for personal and family issues. So how would you do that? Well, let's say you're creating only a business power of attorney. We recommend that you initial line F, which is for business operating transactions. Line F allows your agent to take a wide range of actions to operate your business on your behalf. Our guide will explain what they are, but in general, they would allow your agent to manage your employees, to file taxes, to settle claims, to pay, to access your bank account of the business. This type of power of attorney is called a special or limited power of attorney because it is not a general power of attorney that allows your agent to do everything related to your personal finances and assets. And further, it only allows the agent to do the specific acts listed in the document. You can also use what's called a special instructions form in a power of attorney document to further limit what types of acts the agent can take. This is an example of the special instructions box. In this box, if you look at the bottom line there, it says, the attached Appendix A provides instructions, including information about my bank accounts and other property, and is incorporated into this power of attorney. And we incorporate Appendix A, which include instructions from Betty business owner to Frank friend. And these instructions give Frank friend the authority to access the following bank accounts: Bank of America account number X, Wells Fargo account number X, and the authority to sell her assets. For example, it says you can sell this commercial oven with this serial number, and it must sell for at least $4,000. By including specific details like this, anybody who's receiving the power of attorney would feel more comfortable that you, as the principal, are actually authorizing the agent to do the things that they say they're to do. So we've included example of creating special instructions from the principal to the agent. And this is an example of how you create a special or limited power of attorney in California. Another question with regard to the power of attorney is, when is it going to go into effect? In general, in California, a power of attorney becomes effective as soon as it is signed and authenticated by a notary public. However, a principal can state other wishes in the special instructions box and create what's called a springing power of attorney. A springing power of attorney is one that does not go into effect immediately. It goes into effect in the future. A springing power of attorney may be a good option for a person who wants to ensure that a potential agent cannot take an action on his or her behalf unless a specific condition occurs. It has the advantage of ensuring that an agent cannot use the power of attorney to influence or coerce the principal before the triggering condition occurs. So in the immigrant context in particular, a springing power of attorney may be useful to use. To state something like, this power of attorney only goes into effect if I am detained or deported by US immigration authorities. And then stating that how the agent would prove that that condition had happened. So I'm going to, in a second, show you the language we've included about how you would create this type of springing power of attorney. Before I do that, I want to say, give you a caveat that says there may be disadvantages to using a springing power of attorney in general. For example, many institutions may be reluctant to accept a springing power of attorney as a matter of policy. They might not be accustomed to seeing this type of document, or they may feel they cannot adequately verify that the event, the springing condition, has occurred. In the immigrant context in particular, a springing power of attorney may be difficult to use in circumstances where the springing condition may be temporary, such as if an immigrant is detained but not yet deported. So because of this, making the required proof of the event more official may help make the power of attorney more effective. So we recommend the document should be very clear about what the triggering event is and how the agent will prove that it occurred. In our form document, in the special instructions box, we've provided this type of language. The language states, the powers granted my agent herein shall only be effective if I am detained or deported by U.S. immigration authorities, proof of which requires a declaration under penalty of perjury by my agent that I have been detained or deported, and the presentation of one of the following documents. If I am deported, and then there's a list of documents. If I am detained, and there's a list of documents. This power of attorney will continue to be effective only for as long as I am detained or deported. So what we've done here is the power of attorney document has special instructions. Whoever is receiving the document would look at these instructions to note that this document will only be effective if one of these things has happened, if the principal has been deported or detained. So then the agent would need to provide proof that that had happened. So the way the agent does that is that the agent signs a declaration under penalty of perjury, and they declare that the business owner has been detained or deported. So here we have an example of a declaration that's included with the form. And remember that Frank Friend is the agent for Betty Business Owner. So here Frank Friend would check off that Betty Business Owner has been detained or deported, one of the two, and then sign, I certify under penalty of perjury. This document is then notarized by a notary public. The notary public is certifying that Frank Friend is who they say they are and that they have signed this document. Further, Frank Friend would then check off which proof he has. So he's going to attach different forms of proof. So he could have a copy of Betty Business Owner's issuance of final order of removal by an immigration judge, copy of her issuance of expedited order of removal to show that she's deported. He would attach that to the declaration. When he goes to a bank, Betty Business Owner's bank, to get access to the bank, he would bring this declaration, the copy of that order, and the power of attorney form, the original signed by Betty Business Owner, to show that Betty Business Owner had been deported, that Frank is her agent. Here's proof of her deportation, and this would allow the bank to feel comfortable with granting access to Betty Business Owner's bank account. I'm going to return to the subject of banks in a minute, but in general, that's how a power of attorney works. So now let's talk a little bit more about Frank Friend and how Betty Business Owner would choose this person to be her agent. The first thing to note is that Frank needs to be a legal adult over the age of 18. It's not necessary for Frank to be able to speak English or have any educational qualifications. It's not necessary for Frank to be an attorney. It is very, very necessary for Frank to be someone who's reliable and who Betty can trust. It is probably not a good idea for Frank to be Betty's spouse or intimate partner, because there have been many cases of abuse of these of intimate relationships when a power of attorney is a partner, and that's something you want to avoid. It is important that Frank reside in the same state where the power of attorney will be used. So Frank should be a resident of California, and Frank should be a U.S. legal resident or citizen, or not otherwise subject to detention or deportation himself in the near future. So what does it mean to be an agent? Well, an agent is legally obligated to act in the principal's best interests. The agent has fiduciary duties to the principal, including the agent must keep their own money separate from the immigrant's money. The agent must not stand to profit from any transaction where he or she is acting as the principal's agent. And the agent must not give or transfer the principal's money or property to themselves. Essentially, they must not take the principal's money or property, unless the power of attorney specifically allows the agent to do this. For example, if the power of attorney has a special instructions that said Frank can be compensated, reasonably compensated for his services. Finally, the agent should keep clear records of his or her activities as an agent under the power of attorney. So how long does a power of attorney last? This is what's referred to as durability. If you have what's known as a durable power of attorney, the power of attorney would last even when the principal becomes incapacitated. Incapacitated is a legal term referred to the mental or physical competency of the principal to act. Creating a durable power of attorney may not be advisable for immigrant business owners. Rather, creating a set endpoint may be preferable. The sample form we've included in the guide is not a durable power of attorney. It has an endpoint. And I'll refer back to that special instructions box under the power of attorney form, which has a line that says, this power of attorney will continue to be effective only for as long as I am detained or deported. This is the endpoint on the power of attorney. If Betty, business owner, is released from detention or is returns to the US, then the power of attorney is no longer effective. In addition, Betty business owner has the ability to revoke or change the power of attorney. The way to revoke a power of a business owner is by signing a revocation document and sending copies to anyone who had the power of attorney. Or create a new power of attorney that states that all the previous power of attorneys are canceled. And a disadvantage to doing this is that it is hard to know whether any third party is relying on the original power of attorney. It can be challenging, though not impossible, to modify or cancel a power of attorney while detained or deported. So for that reason, we recommend that you put an endpoint to the power of attorney instead of relying on being able to revoke it in the future. So I talked about the bank, Frank friend going to the bank and trying to get the bank to recognize that he has the power to act as Betty's agent. Sometimes banks will reject your form. Sometimes banks will require that you use their form power of attorney. Legally, they should not do this. If a third party rejects your form, you should contact a lawyer because you have rights to enforce that form and to require the bank to accept it. When I talk about third parties, I'm talking about anybody who's receiving this power of attorney and recognizing that Frank friend has the authority to act as Betty's agent. It could be a bank, it could be a customer, it could be an employee, it could be a creditor of the company, it could be a vendor. So in California, you have a right to require this third party to accept your form, but in practice, it's going to be much harder to enforce that right, to get a court to issue an order requiring the bank to accept your power of attorney. And in practice, it can often be easier to just use the bank's form. So if you are filling out a power of attorney, it might be good to also, and you have a bank that has their own power of attorney form, it would be good to fill out the bank's power of attorney as well. For immigrants who are already detained, it may be possible to prepare a power of attorney while in detention, though it may be difficult to have them properly witnessed and notarized. You may need to contact a lawyer or have a notary visit the detention center to notarize the document. For immigrants who have already been deported, it is possible to use a process called the apostille process. An apostille is a way to authenticate or legalize a document so that they will be honored in another country. You can prepare, create, or amend a valid power of attorney after an individual has been deported through the apostille process. There's more information on this process on page 22 of the Appleseed Guide. So to review, before creating powers of attorney, you want to choose a trusted person who will remain in the United States. You should consider granting separate powers of attorneys to different people for different purposes. For example, one person to handle your business affairs and another person to handle your family and personal affairs. Be careful in choosing an agent. It should be someone who's trusted. Make a list of all the financial matters you would need an agent to help you handle. Use the attached form. Give the original power of attorney to the agent. That means the one that you sign and get notarized. You give that to your agent. You keep a copy for your own records. Ask the agent to keep clear records of all the actions he or she takes as your agent under the power of attorney. If another person refuses to accept your agent's power of attorney, you can consider contacting a lawyer, or alternatively, if you know that the third-party vendor has their own form, you could consider filling out their form. Thank you. We can do some Q&A here before we go on to the next section, which will cover revocable trust. So if anybody has questions now, feel free to either chat them or unmute and you can ask them live.
There's a few new people in the room. If you can go ahead and introduce yourselves. As we get into Q&A, that'd be great. So Juliana, Aldo, Rosita, and Jana.
Hi, this is Aldo. I'm with New America Community Corporations in Oakland.
Hello.
Hi.
Hello.
And Rosita? Great. Jana from NILC. Fantastic. Great to have you here. Natalia?
Great. So if there's no questions, I'm going to hand it over to my colleague, Tobias.
Oh, there's one question from Ricardo.
Oh, there is.
Yeah.
Okay.
Have you seen power of attorney used effectively with business owners who are foreign nationals? Can you give a little bit more background on how that situation played out and any lessons learned?
So the power of attorney we're talking about is for foreign nationals who in many cases maybe what we're talking about is undocumented business owners who would be foreign nationals residing in the United States. What we're describing is a process by which they can use this power of attorney form in California to appoint in case of detention or deportation.
Ricardo, did you get that?
But we don't have any situation where we're not aware. We don't have examples to give yet. For us, this is a first foray into the whole process of using the document.
And then Rosita asks, how can I get a video or written copy of this webinar so I can go over it and start preparing? We've recorded this webinar, so after this session, we'll send it out to folks. And then we'll also send out a checklist as well and resources for you to take a look at. Great, any more questions?
Yeah.
All right, if not, then Tobias is going to get to the second part, which is revocable trusts.
All right, thank you very much, Sushil and Antu. Now I'm going to talk about revocable trusts, which is another tool that undocumented non-citizen business owners can use to protect their business assets. Let me just, okay. So a revocable trust is essentially a legal document or a legal tool that an undocumented business owner can use to ensure the continuity of their business operations and that their assets remain in trusted hands and can be recoverable by themselves in case they're detained or deported. So in the document, in the revocable trust document, it designates a trusted person who's called the trustee to carry out a contingency plan for the owner's business and any other assets mentioned in the trust in case of detention, deportation, mental incapacity, or a death of the owner. So a business owner in a revocable trust retains the right to modify or revoke the trust while they're still alive. And this is why it's called revocable. So at any point while they're still alive, they can regain ownership and control of their business and the other assets in the trust from the trustee if, for example, they're released from detention or they return to the United States after being deported. Some other important things to note about revocable trusts is that they can be created by both single people, a single person or a married couple. And in our guide, we have sample revocable trusts for both a single person and for a married couple who are business owners. So you can see that once you get the guide when we send it out and it's published. Also, if a business owner doesn't have time or the resources to draft a revocable trust, they can choose to include the power to create a revocable trust in the power of attorney that they draft. So essentially, their power of attorney can give their chosen agent the power to create a revocable trust on their behalf. I wanted to go over an example situation where a business owner creates a revocable trust to protect her assets, just to provide some concrete details before I go into the more abstract characteristics of revocable trusts. So I'll be referring back to this when I go over the characteristics of revocable trusts and how they're created. So in this example, we have Claudia, cafe owner, who's also in the template trust in our upcoming guide. She runs her own cafe as a sole proprietor, so she owns it by herself. And she has two daughters, Mary and Patricia. She wants Mary to take over the cafe in the event that she is detained or deported. So in order to ensure that that happens, she creates a revocable trust. So she basically writes up and signs a trust document detailing her assets and what will happen to them if she gets detained or deported, or becomes mentally incapacitated or dies. So then she has to transfer all of her assets, including her business assets, from herself to the trust, so that the trust becomes the owner. There are various ways, depending on the asset, that that she will need to do this, and I'll go over that in more detail later. So once the trust becomes the owner of her business and her other assets that she chooses, she still manages the cafe. So she still retains essentially the same rights that she had when she was the direct owner of the cafe before she created the trust. But once she creates the trust and transfers ownership of her business to the trust says that she still maintains her right to manage the cafe. As I mentioned here, or I mentioned before, she has to transfer legal title of her business and her assets that she wants to protect from herself to the trust. Since she's a sole proprietor, she transfers her business from herself to the trust by a simple assignment document that says she assigns her ownership rights to the Claudia Cafe Owner Revocable Trust. And she also has a house in this example. So in order to transfer ownership of her house from herself to the trust, in California, she needs to record a new deed that says that the trust is now the owner of the house, and record it with the county where she lives and the house is located. The terms of her trust say that she is the initial trustee. So the trustee is the person who essentially manages the trust property. And that if she's detained, deported, or mentally incapacitated, her daughter Mary becomes the successor trustee and manages the cafe on her behalf. And if Mary can't or won't become the successor trustee, then Patricia becomes the successor trustee and manages the assets in the trust on Claudia's behalf. The trust document that Claudia draws up also says that she can amend or revoke it at any time while she's alive, as I mentioned before. So if she's released from detention or she returns to the United States after she's deported or regains mental capacity, she can revoke the trust, i.e. cancel the trust, and transfer ownership of her assets back to herself. But then the trust also states that if she dies, the trust becomes permanent, which means that it becomes irrevocable. No one can cancel it anymore. And then in the trust document itself, it specifies in detail how her cafe and her other property, i.e. her house and her bank accounts, are distributed to her daughters. So now I want to talk about the abstract characteristics of a revocable trust. Now that we've gone over concrete example with details, and I'll refer back to the example when I'm talking about what a revocable trust is and explaining how it's set up. So first of all, I wanted to go over in general what a trust is. It's a formal legal relationship documented in writing between the settlor, who's the original owner of the property. This would be, in our example, it would be Claudia. The trustee, the person who's responsible for taking care of the property in the owner's absence. So in this example, it would be Claudia, who would be the initial trustee. of her own trust, and then if she's detained, deported, or loses mental capacity, then it would be her daughter Mary, and if not Mary, then it would be Patricia. And the beneficiaries, who are the persons benefiting from the property in the owner's absence. So the beneficiaries would be Mary and Patricia, and they would, the trust property is managed for their benefit. So once Claudia dies, it's distributed, the trustee of the trust distributes the trust property to them according to the trust terms. But initially, Claudia is also the beneficiary of the trust. It's just that her daughters, Mary and Patricia, become the beneficiaries after she dies. A trust is generally a written document. In California, it's called a declaration of trust or a trust agreement, but here we'll use just declaration of trust. Another way to think of a trust, since it's an abstract concept, is as a virtual safe deposit box for property that someone wants to protect. So it's like a legal safe deposit box that someone can deposit their property into. And once it's deposited in there, it has certain automatic protections that kick in when certain events occur. So as I said earlier in the example, a revocable trust is a trust where the settlor, the original property owner, retains the right to modify or entirely revoke or cancel the trust. So, you know, think of a virtual safe deposit box for the settlor's property with certain automatic protections. Instead of being permanent while after the owner dies, the original property owner can change the characteristics of the box at any time while they're alive. And they can also, if they want to regain direct ownership of the property, they can take steps to make the safe deposit box disappear and regain direct ownership of their property by revoking the trust. So to answer the question, how can a revocable trust be revoked? In California, it's possible to revoke the trust through any way listed in the Declaration of Trust, which can limit the methods of revocation if the person setting up the trust wants to limit them. And if there's no limit to how the methods of revocation in the declaration, the person setting up the trust, the original property owner, the settlor, can deliver a written and signed document to whoever is the trustee at the time, saying that they hereby revoke the trust. If the settlor revokes the trust, the trustee then needs to transfer title of all the trust property back to the settlor or the original owner. So let's say Claudia, cafe owner, wanted to revoke the trust. If her daughter Mary were the trustee, let's say Claudia's released from detention or returns to the US after being deported, then her daughter, and she gives Mary a document saying she wants to she's revoking the trust, then her daughter Mary would have to transfer legal title of her business and her house and her bank accounts and any other property that's owned by the trust from the trust back to Claudia and go through all the legal formalities to do that. So now I want to talk briefly about the benefits and the downsides of forming a revocable trust in the context of immigrant business owners. So the benefits are that it places the business and other assets, whatever other assets the person chooses, in the hands of a trusted person who's a trustee. in case the owner is detained, deported, or mentally incapacitated or dies. And the trust protections are automatic. So once the property is owned by the trust and the trust is set up, you know, if the triggering event occurs, like let's say the original owner, the settlor, is detained, then you know, the successor trustee is automatically appointed, and the trust document specifies exactly what they have to do and what powers they have to keep managing the property for the business owner. The downside of forming a revocable trust, though, is that trusts in general take significant time and money to set up and maintain. For example, a business owner may have to pay a lawyer to set up the trust and pay a professional trustee to maintain it. And any cost-benefit analysis that a business owner does to decide whether they should expend the time and money to set up a revocable trust should include how high their risk of detention or deportation is, the value of their business or other property that they want to protect, like whether it's really high value or not so high, their own time and ability to draft a declaration of trust and manage the trust, and you know, having the availability to them of having other people who they trust who are capable to manage it in their absence, and the need to ensure that, like, you know, whether there's a really strong need to ensure that the business continues to operate and that funds are provided to any dependent children or other dependents that the business owner may have. You know, like if there's not a strong need to ensure that their business continues to operate in the event that they're detained or deported, then it may be simpler to just not set up a revocable trust and use a power of attorney instead to appoint an agent to wind down the business if they're detained or deported. So what are the legal requirements to form a revocable trust in California? First, you need a settlor, which is in this case the business owner, who intends to form a trust. Then you need a trustee to be available in case of the events listed on the slide, who's the successor trustee. And you need to have beneficiaries. So the trust document needs to designate people who are the beneficiaries of the trust, you know, who will benefit from the trust property if the business owner dies. And the trust doesn't have to be in writing technically, but it's definitely always advisable. So we wouldn't recommend forming a trust just via an oral agreement with someone. It should definitely be in writing and signed. And again, you can use the templates that we'll have for either a single person or a married couple in our guide, which will be published soon. Then you also need ownership of the settlor's assets, in this case, business assets, and any other assets they choose to be transferred to the trust. So from the owner to the trust. This is also called funding the trust. And in California, transfer of ownership of real property, for example, a house or a condominium, requires that the trust be written. This is one other reason why it's always advisable to have a trust in writing. And if ownership of a house or an apartment or other real property is transferred to the trust can also be recorded with the county recorder where the real property is located. And finally, of note is that in California, trusts are presumed to be revocable unless the trust clearly states that they're not. But it's still advisable to include a specific method in the trust that someone can refer to when they want to revoke the trust or amend the trust. So in this case, we have an initial trustee versus the successor trustee. And I already mentioned how after the settlor forms the revocable trust, so when Claudia forms the trust, she also serves as the initial trustee while she's alive and still in the United States. And, she, although she's transferred ownership or legal title of her business and other property to the trust so that the trust becomes the legal owner, she still retains the same rights or the same powers. For example, the abilities to manage, sell, or invest her business or her house. In this case, the declaration of trust must also specify a successor trustee to serve in case Claudia is detained or deported or mentally incapacitated or in case she dies. So what are the most important things to consider when choosing someone to be specified in the trust as successor trustee? They should be, first off, most obvious, a trusted person for the settlor. Second, able and willing to do the work of managing the trust. So someone who has the time and the skills and the capacity to do that. Third, the person should ideally be a US citizen or a legal permanent resident or AKA a green card holder. I.e. someone who doesn't have any risk of being detained or deported from the United States. And then fourth, someone who honors the settlor's wishes. And fifth, someone who will work well with the settlor and the beneficiaries and their family members. Another option, if such a person can't be found, is to hire a professional trustee, which could be a bank's trust department or a person licensed in California as what's called a professional fiduciary. And this is more expensive for obvious reasons. And it may not be very the best option because a bank may not be willing to manage a small business. They may be used to just being appointed as a trustee to distribute assets in case someone dies. And they wouldn't want to devote someone's time to managing the day-to-day affairs at a small business. But it is an option to consider if someone can't find someone in their personal circle who can serve as their successor trustee. So I mentioned that for a trust to be created in California, it needs beneficiaries. Who are the beneficiaries? The beneficiaries are the person or the persons who are entitled to benefits of the trust property upon the triggering event. And in Claudia's case, it's upon the death of the settlor, or upon Claudia's death. So it would be Mary and Patricia. And benefits from the property can include income from business and profits from the sale of the business, as it's specified in the trust document. So one thing to note about beneficiaries is that there's a legal requirement that they must be an identifiable person or a group of people. So it's really best to state who exactly will be the beneficiaries, like their name and their address and their age in the trust. The trust document itself you can't be too vague when identifying beneficiaries. So I already mentioned how Claudia takes steps to transfer ownership from herself to the trust when she's setting up the trust, and that is called funding the trust. The procedures for transferring property depend on the type of property involved. In general, a declaration of trust includes a list of property. Just for reference, but the legal title has to be changed from the original owner or the settlor to the trust. And you know, it doesn't technically have to be included in the schedule as long as the trust becomes the legal owner, the property belongs to the trust. And one important thing to note is that when transferring property to a trust, the legal title to the property should always be in the trustee's name and contain the date of the trust. So there's an example on the slide. Claudia Cafe owner, trustee of Claudia Cafe owner, revocable trust, dated, and then the date that the trust was formed. To continue on this topic, some examples of transfer procedures for commonly seen property that we'll describe in more detail in the upcoming guide. So for example, for a business, the business owner should carefully review the business documents and, if necessary, get advice about legal restrictions and specific requirements for transferring ownership of the business from a licensed attorney. When transferring bank accounts, the owner should usually use the bank or the brokerage's own certification of trust form to transfer ownership. Sometimes banks or brokerages require the person to open a new account in the name of the trust and then transfer their bank account funds into that new account that's in the trust name. But it's not really, it's just an extra step. It's not really a lot of hassle. For real estate, in general in California, the settlor has to execute a new deed transferring title from him or herself to the trust and record it with the county where the property is located. One very, very important caveat when doing this is that if there's a mortgage on the property, the settlor will need to contact the lender to notify the lender of the transfer. And it's really important to get their assurance in writing that the loan won't be called, meaning that the full amount of the transfer, the full amount of the transfer will be due the full amount of the loan will be due once the transfer is effected. So that's very important to remember because a lot of mortgages have provisions saying that if there's a transfer of ownership, the full amount outstanding of the mortgage is automatically due to the lender. Copyrights or any other intellectual property can be assigned in a separate notarized document. We have templates for these documents in our upcoming guide as well, and they should be listed in the attached declaration, the attached schedule attached to the declaration. Some special considerations for non-citizen business owners are that if the settlor doesn't have a social security number, they need to apply for an individual taxpayer identification number to form a trust. And we provide more detail about that in our guide. Also, if the settlor is deported, the trust may be considered a foreign trust by the IRS. And they need to define detention and deportation specifically in the Declaration of Trust and specify which documents the successor trustee needs to use to prove that they've been detained or deported. And we'll have more details about that again in the upcoming guide. So now I want to open it up to questions. If anyone has any questions about this section, you can either unmute yourself or ask the question in the chat. I think we're a little short on time, but we have a few minutes.
One question from Aldo, which is, does LCCR help to form a revocable trust?
Okay, good question, although we can make referrals to trust and estates attorneys. We currently don't have that capacity in-house, but we're looking to expand the capacity of our network to handle formation of revocable trusts and drafting of power of attorneys or advising about power of attorneys. So stay tuned. We will have more announcements on that later on.
Any other questions? And you can write them into the chat as well, or just, we're not a big group, so you can just put them out there.
Okay, well, I think if there are no more questions, then I'll hand it off to Antu. Thank you very much.
Great, thank you, Tobias and Sushil. Extremely informative, and I hope that this is useful to the rest of the group. I know that some of y'all joined a little bit later, and just wanted to mention that we do have this recorded. So after the webinar, we will send out an email to everybody who was registered and participated, so that you can get a copy of the recording. Since I know that it's there's quite a bit of information, it's a bit of a heavy lift. So next up, I'm going to be speaking specifically to the maintenance and dissolution of assets. So basically what to do with your business and personal assets in the case of a life-changing event, such as detention or deportation. That again can be applied to other major life-changing events as well. So we will get started. Now let me put up my slides. So the assets that we're going to be speaking to specifically are businesses and ownership interests, bank accounts and cash transfers, liabilities such as loans, mortgages, and so forth, real estate, vehicles and other valuables, and paying taxes. First, thinking about dissolving a business or business interest after you've, a detention or another life-changing event. Generally, if you're closing a business, you should notify the Secretary of State, the county and city clerk's office, local and federal tax authorities. You may not have to notify most of these entities if you are a sole proprietorship, but if you're incorporated as an LLC or otherwise, then you should get that taken care of. You should also, if this applies, look into notifying licensing entities and trade associations that your company may be a member of, as well as creditors and suppliers, importantly, and then customers. If you are selling your business or a share of your business that you co-own with others, you may want to look into hiring a business broker, especially if you want to sell to somebody else who isn't a co-owner or a family, a friend, community member. And just see what your options are. The business broker can help you perform or find people who can perform a valuation. And when you're performing a valuation for your business, do consider your shares, your bank accounts, your debt and other liabilities, licenses, real estate, and other properties such as equipment that your business may own. And like I said, you can hire a professional to do this, especially if there are other co-owners involved and you want to get a very precise number for the value of your asset. If your outstanding debts are valued more than your business, which happens more often than not, especially with small businesses, what you can do is transfer all the assets to an assignee, that is a liquidator, that can sell the assets and distribute the proceeds to creditors who file claims after being notified. If you do power of attorney, an agent can help do that as well. Then there are other forms of debt discharge. That's, for example, cancellation of debt. If you notify creditors in advance and it's a small debt, that can be an option, or bankruptcy. If you have co-owners, dissolving a business might be a little bit more complicated. They might want to have your share. There might be other extenuating circumstances that might make it a little bit more difficult, but there are things to consider when you have co-owners, which is that based on your contract, your co-owners may have right of first refusal, which is an agreement between the business owners that give a right to buy something before that offer is made available to others. And that the share of the business, the owner's share of the business, has to be sold to the co-owners, or must be offered to the co-owners before it's offered to anybody else. So you should check to see if that's in your contract, or if that's something you might want to set up with. You haven't organized your business yet with partners. And there's consent notification. You should check to see if the owner's agreement requires consent from co-owners to sell an interest. Usually co-owners want to know who you're going to sell it to. And that the agreement may at least require the seller to tell the co-owners about the sale, that it's happening. Again, this is going to be especially an issue with a small business. Then there's a change of control provision that owners' agreements may have to look into, which is that some contracts require that upon a change of control, a business owner, before selling their interests, has to notify the bank that loaned the money to the business, or the bank that holds the business's mortgage, or any entity that gave a license to the business. This is so that the lender knows what's going on and who's owed what to whom. If a change of control provision is triggered by the sale of his or her interest, then the owner must follow its terms. Next, going into bank accounts. For opening and maintaining a bank account, if you're thinking of opening a bank account now or later, do consider one with international access through online banking or banking by phone. And then also consider cards that have chip card technology if that's offered through your bank, because that's many international ATMs and will only take chip card technology. Many credit unions that have this in the US, and major banks definitely have this. Also consider setting up a joint bank account. However, the person that you add to the joint bank account will legally own everything in this account as well. So the other person should be a trusted person. And also consider that the account could be taken by the other person's creditors if they have debt. And also that if you die or are otherwise incapacitated, the other person may get all of your money in the account. And then also consider, when setting up a bank account, consider financial limited power of attorney, in which an agent can manage the account on your behalf in case of detention or deportation. And Sushil and Tobias went into a little bit earlier. Some banks don't allow for powers of attorney, or they have to provide a very specific form to fill out, but you should check with your bank in advance. If you're closing a bank account and you have no consider if you have no financial obligations in the US, or if you have any financial obligations in the US as part of your rationale to do so. If you don't have any financial obligations and you need easy access to your money in your home country, it makes sense to close a bank account. If you do, like for example, you have a mortgage or you have like outstanding loans still could consider keeping it open because that just might make things easier for everybody. Make sure all of your checks and automatic payments have cleared before closing the account. There may be special procedures if you have a joint account. If you're closing your account from abroad, you will have to write a letter with specific information to your local branch. And money will be given as a check, transfer, or can be loaded onto a prepaid card. If you anticipate like a high risk of deportation, do consider opening a bank account in another country. Because for a bank draft or wire transfer, you will already need an account in the home country in order to close your account and easily transition it to the new account. And these are all much safer than trying to carry cash across the border to another country. With regards to loan and credit card debt, debt does not disappear when an owner leaves the country. It will always exist. So as tempting that that might sound, it's still, if there's any possibility of returning to the US, that debt will continue to exist. Interest, fees, and penalties will continue to accrue regardless of whether the person's in detention or has been deported. However, you may be able to make an alternative payment arrangement directly with the lender, such as an extended payment period or change in repayment amount. The lender may seek to recover unpaid debt, and they have every right to. Once the debt reaches a certain level, the credit company may cancel a credit card and may sell your debt to a debt collector. If a lender sues in a US court for non-payment and wins, they can enforce the judgment abroad if there is an agreement with the US to allow it. And also, if a lender sues in the US, they can win even without your presence. That's called a default judgment. With regards to real estate, that can mean any owned land or building, for example, a home, an apartment, a business location, anything that touches land. In terms of keeping your property, if you want to keep your property in the US, you can retain ownership even if you are detained or deported. And if there is a desire to do so for whatever reason, if you have family that can manage the property or so forth, do make arrangements such as power of attorney for the property to be managed and all loans and taxes to be paid in your absence. Property taxes must be paid regardless of status or whether you've been detained or deported. They will accrue and we can open the property up for foreclosure. With regards to selling or gifting property, if there is a loan for and mortgage on the property, the lender must consent to any transfers. This may result in taxes that must be paid by sellers and by givers and receivers of gifts. And for co-owners, if a co-owner is not at risk of deportation, you may consider having them take care of things in your absence. You can consider transferring to co-owners your entire interest in the property or otherwise give them a right by limited power of attorney to act on their behalf with respect to the property and any related loans. You should, in terms of selling or gifting your property or selling to co-owners, you should consult a lawyer in advance so that you know which transfer is more beneficial to you and the receiver of the gift. So for example, if there's a mortgage on real estate and the lender doesn't approve the transfer, the gifting may result in default. With regards to mortgages, if there is a co-owner, regardless, you are responsible to pay the lender the full amount of the loan. If you continue to own the property, you must continue to make all your regular payments. If you sell or transfer the property, you will need to pay the lender the full amount of the loan and any other charges due under the loan documents. Then you can keep any remaining funds. And if you do not think that you'll be able to pay your loan, you should reach out for help in your state to understand the full risks and find out if there are any protections. If there's a co-owner, the actions which affect the loan and mortgage will oftentimes require the cooperation and or consent of the co-owner. And if there are consequences for non-payment, basically means that the loan will be in default and the lender can foreclose on your property. You can provide a limited power of attorney to someone so that they can work with the lender and take steps to avoid a foreclosure. Or if this is possible, you should just reach out to your lender and try to put a feasible plan in place. In addition, keep copies of all communications with the lender and the lender's contact information. The second most valuable thing that a business or a person may have is usually their vehicle. And then with other valuables and how to dissolve them. If you own your car outright, you can sell or export it. However, exporting can be complicated. It might be simpler to sell your car in the US and buy a new car in your destination country. Again, providing a power of attorney for someone who can take care of this would be the best course of action. If you have valuables, your options include selling, where your representative can value and sell them, or you can ship them to a destination country or store them in the US if for whatever reason you believe you'll be returning to the US or you have family in the US that can use them. Paying taxes, even if you have been detained or deported for tax filing purposes, you will be considered a resident alien for tax paying purposes. So under the substantial presence test, which is section 7701B of the Internal Revenue Code, most immigrants are classified as resident aliens for tax purposes and must file the standard form 1040. A resident alien basically is anyone who maintains what's called a substantial presence in the US, which requires 31 days of presence during the year in question. So if you were detained and deported on February 1st, 2017, you are considered having a substantial presence and a resident alien for the year of 2017. Or it is the sum of the number of days of presence during the year in question plus the 2 preceding years that it comes out to at least 183 days after waiting. Basically, most likely you're a resident alien for tax filing purposes. And even when you're back in your home country, you might be continue to be treated as a resident alien as long as the substantial presence test is satisfied. So as a result, you must file a tax return if your income is above a certain level, depending on filing status, age, and type of income earned. And even if an individual is not required to file taxes, they can file to receive a refund of any overpaid taxes or receive tax credits such as the earned income tax credit. So to review, again, a plan is essential, and issues to consider when creating a plan is minor children, dependents. If you're a business owner, if co-owners are involved, and what that might entail in terms of setting up a plan that works for you. If you have any property, high value possessions or bank accounts, loans, credit card debt and mortgages, or if you've been receiving any government benefits, basically to take all these into consideration. And also if you have financial documents, you should probably have them all organized in one place so that you can, or a representative of yours can have a quick look at them and have easy access to them. So any questions? Any questions for anybody, or it's pretty straightforward? Great. Natalia asks if we have contact information of lawyers that do pro bono for these type of procedures. So at Dowley, we have some contacts with lawyers that do pro bono work through legal clinics, depending on the state. With regards to LCCR, how do y'all do your intake and referrals?
Yeah, LCCR also has lawyers that we can match clients with. So we do intakes if you are located in the Bay Area, California. We generally work with clients in Northern California. Contact Tobias Damm-Luhr, whose email will be distributed after this.
And I'm based in New York City. We have a satellite office in New York City. Our main office is in Oakland, so our connections will be with LCCR out in California. But if there are folks in New York City or in New York State that need pro bono assistance, we can absolutely put in touch with them. We work with Urban Justice Center and we work with CUNY Law, amongst other clinics that we've been in touch with. And we also are connected to a national network of pro bono attorneys as well. Any other questions? Great. So I guess we're going to end a little bit early. We'll send out, LCCR has a checklist, and they'll also be sending out their packet as well, their manual. And that will be in the next week, Sushil and Tobias? Is that
yes.
Right? Okay, great. And then also we'll send out a recording of this webinar for everyone to take a look at. And if you have any questions, please be in touch with us. We should, with Tobias or myself, and we'll send out our information shortly. All right, anything else? Any closing comments?
Just thank you all for attending. We really appreciate it. And that we hope that the presentation was informative and that you got some good information out of it. And yeah, we'll, I think we have a slide with our contact information that I can show.
Yes. Yeah. I can share that. Oh, and here's a list of resources as well that we'll also send out with the rest of our information. So LCCR's upcoming guide for non-citizen business owners in California, the Appleseed Network's guide, which is invaluable, some access to New York statutory short form power of attorneys if that's relevant, and Mission Asset Fund's Financial Emergency Action Plan for Immigrants, in addition to the checklist that we'll be sending out. And then here's our email if you want to be in touch, Sushil, Tobias, and myself. So if there's any other questions or closing comments that others participating might have, do let us know, and please do reach out to us. And yeah, I guess we'll end a little bit early. And thank you so much for taking part in this webinar, for participating. We hope that'll be useful and that you can bring this to the communities that you're working with and fellow entrepreneurs. And if you have any questions or have any concerns, please feel free to reach out to us.
Thank you.
Thank you, everyone.
Thank you, everybody.